feel extremely privileged to share with you today my thoughts on intellectual property in the tobacco space. This research project that we'll be presenting has been made possible through sponsorship by the Foundation for a Smoke-Free World, and I'd like to thank them for making this type of new thinking possible. I'd also like to thank the organizer for putting it together in this COVID time. Such a great event. It's been wonderful to be here and just to meet people in real again and not on Zoom. So with all of that being said, let me introduce you to the research that we did during lockdown. The idea started off with me sending an email to Dr. Derek Yack, who's the founder of the foundation, saying, have you guys ever thought about patents? He said, no. I said, wow, you're working on innovation, you're working on new technologies, you praise vaping as the new way forward, and you haven't given patents a thought. That's kind of impressive to me, because I don't see how you can make one possible without thinking about the other. So point was taken, and we embarked on, I think, one of the first projects that seriously starts thinking on patents and new technologies in the context of smoking and fighting the smoking pandemic. And what I'd like to do today is present to you the findings of this report. But before we do that, and before throwing you into the water and bottling you up with patents, I think it would be good to share with you my passion for patents. Because I don't think I'm speaking here to a primarily legal audience or to other patent nerds. So why does intellectual property matter? I started off in IP 20 years ago after I nearly had a career with WHO, which didn't happen. And I had no idea about intellectual property. I'm a trade economist, more or less. And at the time, my boss said, well, there are 5 different versions of intellectual property. That's all you need to know. I was like, okay. But then I realized that what we're really talking about is not patents, trademarks, copyrights, etc. What we're really talking about here is ownership, about knowledge, about creativity, about new views, new perspectives, about new ways of seeing the world. And we're talking about how are we going to organize and manage property rights, private property, over what's in our brains. I thought, wow, I can't think of anything more revolutionary and more exciting than that, really. In a way, the question arises, are we taking capitalism to the next step? Will after intellectual property, emotional property follow? What does that mean for marriages? And on the other hand side, I also thought, like, if we are speaking here about having stacks of private property, of private ownership, or what's on our mind, we are basically revolutionizing a lot of stuff. We are revolutionizing how we are organizing an economy, how we are perceiving the questions in politics, how we are organizing society, and how we are going to run our business. Weird enough, very few people saw it like that and still don't see it like that. And I find myself speaking to a bunch of patent attorneys who say, wow, I had no idea what I do has any meaning to the world. So it's kind of like good to reach out to another crowd every now and then. I really think that just looking at intellectual property as a source of protecting certain inventions or technological breakthroughs is a very limited way of defining the term IP. I think, particularly in the 21st century, growth rates are driven by innovation, are driven by new technologies, and this is mainly like common knowledge or know-how in, I don't know, in economic research that if you want to move forward, it's about leading through innovation. Where I see this mismatch and the gap is that everybody likes to lead through innovation and to educate leaders in innovation, etc. But what role the property rights that underpin this innovation can, should, must, or should absolutely not play is kind of like swapped under the table, and we leave it to the lawyers and the judges to somehow square it up. Unfortunately, judges are here they're not here to make politics. Judges are supposed to figure out how to make sense of the law. And these are often different questions, and judges are also not politically elected democratic representatives. So I think it's important that we take the democratic governance process back to policy making rather than leave it to the judiciary. And the judiciary, at least in the UK, thinks this is fine. We're still trying to crack the policy side, though, to motivate them. And I liked what Jill said about how politicians think. IP is also not exactly on the forefront of politicians' minds. And I think this is completely crazy because everybody wants great technology and great technology politics. But how are we going to structure, to take the details of it, how are we going to organize the IP and the standards? That's kind of like not really that sexy to sell to the voter. So I think IP is really the elephant in the boardroom, and other than just what is kind of like a missed out question in policy circle, unfortunately is also a missed out question in corporations very often. This goes as far that even high-tech companies, CEOs, in my opinion, lack adequate understanding of business strategy around intellectual property and of how to take their knowledge, proprietary assets forward. And then it lands again with the legal team, and this is not the role of the legal team. They will tell you, God, do you have any idea how many risks are associated if I touch that, people? I will not, I'm staying the hell away from this, and if I can keep you also out of trouble, we are all happy. So do not pass it on to the legal team. And so you have kind of like a gap in the system, and that gap leads to a way of looking at IP which I find is very conservative, and that is the paradox. We're having a governance structure that helps frame the basis of innovation, but how we are thinking about it is exceptionally not innovative, and rather, well, the law is always very cautious. So rather cautious and rather backward-looking. And even with international treaties such as TRIPS, I think they're backward-looking, and technology has been so much faster than how the lawyers have been able to think about it that there's a mismatch. The biggest mismatch, I think, is the drama between international business and the geographically limited intellectual property system, which completely doesn't fly. And TRIPS is a bit of a compromise beyond that. So with this very small introduction to my world, yeah, maybe one thing which I'm seeing specifically in tobacco, I would say this is not patents is not in the DNA of tobacco corporations. This is a consumer industry. It's about the brands, the trademarks, the perception, and this is where the core strength is. Patents, in my opinion, was more a reaction to a major governance change, to the Framework Convention on Tobacco Control, to concerns by public health advocates. The industry had to do something. I mean, innovate or perish, that was basically the choice. So innovation was on the agenda and patents came with it. So helping a sector which is not sort of like born with patents or has made its success from the outline with patents, leapfrog into a new patent paradigm, I think that's going to be the big challenge and the big opportunity also. And what I'm currently seeing, like the patent disputes between major corporations and patent infringement allegations, that's unfortunate, but I think this is not the key strategy. The key strategy has got to be how can the industry team up to think about intellectual property from a public health, public interest perspective rather than fight each other. But I'll come to that in a second. So with this sort of like more bigger picture background of IP, a short intro from a non-legal perspective, I'd like to now come to some of the findings of the patent landscape report which we undertook. So I only trust the numbers I manipulated myself. Don't think these numbers are 100%, they are absolute. This is all like rough estimates. Different people will probably come up with different numbers, and the drama is also collecting patent data is new. the European Patent Office has started working on this a few years ago only and has teamed up with other patent offices to have a pool of patent information from offices around the world in Munich. And our sources of data come from the EPO. The catch is how different patent offices around the world collect the data is different. They look at it's not 100%, that's what I'm trying to say. Nonetheless, I think we can have a bulk figure of roughly 70,000 patents, which we have been able to count in the tobacco space. And I would say, given that this is like what we saw in terms of patent volume being generated over the past 10 years, I think this is an okay number, and it shows the efforts of the industry to create game-changing new perspectives on tobacco. That we can say for sure. Maybe, I'd say I do a lot of work in the ICT space and work in high-tech a lot compared to what we see in areas such as artificial intelligence, medical AI, IoT, Internet of Things. This is a ridiculously low patent volume. But then again, we're speaking either of connecting the whole world and creating total interconnectivity in some way or another, or we're speaking about the cigarette. The products are not the same. The level of sophistication is not the same. The way we are trying to transform something is not the same. So I would say, given we're talking about a cigarette that we're trying to innovate, this is a fair volume, and it shows an effort to invest in innovation. We tried to, and sorry, what I should say, this is the patent volume, sorry, I forgot to say that, only for technology that aims to reduce harm. So these are not patents which are related to vanilla-flavored tobacco or something like that, or strawberry-flavored tobacco. We just try to understand what's been the effort. Can we somehow quantify the effort of tobacco harm reduction technologies or technologies that have that as a goal? And we classified this term into 3 large areas, which is nicotine vapor products, smokeless nicotine products, and heated tobacco products. And we used for that definitions from the US government. I think from the FDA, they classified that in that way. So, well, that's a fair way of classification. I think if we look at the growth rates of around, well, 20 to 40%, depending on the type of, well, not the growth, but the distribution rate, we see around most effort has been gone into heated tobacco products, and followed by nicotine vapor products and smokeless nicotine products, with a growth rate of around 4 to 10%. I really think it is okay, it is satisfactory. Again, you look at AI, the growth rates are different, but AI is a different story. So we are seeing here a clear proof, a clear body of intellectual property that's been generated by a consumer products industry which is not naturally married to IP, or which had which made its success on the basis of patents. And that's a good sign, I would say. What we also saw in the patent landscape analysis was a switch, a starting point of switch in the industry to move towards more therapeutically focused areas, and to look at new technologies such as biological sensors, which allow to monitor users. We are also looking at shift in focus from recreational use to a more measurable therapeutic use. And we're also seeing interesting new partnerships between insurance companies and health bodies, and overarchingly, the goal towards greater access. I must say, when we started off with this research, nobody expected that to see. So that was kind of like a surprise for us. And it would be really interesting to compare these results to what the pharmaceutical industry is doing in terms of helping people stop smoking from the outset. It would be good to see how their patent position looks like, and how much they have invested in intellectual property in that space, to see how holistically the innovation position looks like. Don't get hung up on these numbers. Size is not everything. I would not say that because Philip Morris has a few more patents than British American Tobacco. Their patent space is by definition better. Just because you have many patents doesn't mean you have better patents. The Nobel Prize was not given to the person who has written the longest dissertation. So, yeah, volume has a certain indication that you're doing something, but what we're really after are who has really, really strong patents, who has really valuable patents, not who has just many patents. Fat and strength is not the same. But at this point, we were not able to get into such depth. And I would see this as a rough indicator. It is also difficult to judge what is happening in China. Chinese are pursuing a different patent strategy traditionally in other areas as well from US and European companies. They're very much pushing for volume across all technology areas. And it is a bit difficult to understand what the quality of their intellectual property is. As a next step, it would be good to identify perhaps indicators that make some statement of value and of economic relevance, and in this specific context of public health indicators as well. So what is the public health value of this intellectual property? That we do not know. We just have counted them, how many are there, roughly speaking. And we see also new players such as Bayer, traditional pharma company, mingling actively in this space. I think that's interesting. And other than BASF, also German chemical company, active in that space, that was a surprise for me. And we're seeing slightly different distributions of the portfolios by number according to heated tobacco products, nicotine vapor products, and smokeless nicotine products. And my impression was that the trade war between China and the United States is also showing in this specific patent pool situation here, with China pursuing apparently a slightly different strategy on tobacco harm reduction technologies as the United States or the United Kingdom. This may be due to other regulatory environments, to other goals, etc., that the Chinese are pursuing. Overall, we're seeing here, I would say, a patent war also that is occurring between China and the United States in terms of volume and in terms of, how shall I say this in a friendly way, in terms of making the companies that have important intellectual property in the other countries part of the world life more difficult, pursuing injunction. We see the patent threat in the trade war in intellectual property very clearly in this space, but also in medical AI, for example. I hope this can eventually be overcome, this drama. It's beyond my scope of influence. Then I think what gave me a big shock, I have had a career in international development. I tried to work for the UN, help developing countries come to grips with intellectual property at an early stage of my career. If ever I retire, I'll write a comedy about that experience. But what I did not expect to see was the massive gaps we have between patent filing strategies in developed and developing countries. More or less, to say it boldly, the developing countries have been left out in that innovation strategy. And I don't want to blame anyone, I don't want to put the finger. I know the situation of patents in developing countries, and I understand why many corporations are just reluctant to even put up with this. On the other hand side, if there is no patent activity in developing countries, it is, as a rule of thumb, a suggestion that a company is not intending to sell its patented products in these countries. That's how you file patents. You file patents where you want to sell your products. If you think a country is not going to be a market for you, you usually don't file there. So if I'm not seeing any patents in a region, this is for me a very strong suggestion that there are also no products, there's no goal or aim of selling products in these areas of the world either. And that is problematic. I'm not a public health professional, but I see the data and I know that the smoking pandemic is particularly pronounced in those very countries where we're not aiming to get the innovation through to. That's wrong. There's nothing else to say, but that's wrong. In those parts of the world where smoking is strongly putting lives at risk because other development challenges that people are facing there, to not have as a goal to make sure that supposedly better technology is available there, that's not good. We can't just save the lungs of Americans and Europeans. We need to help people around the world and give them access to what we think is the better technology. And I think this is one thing where something needs to happen. And what is very odd here is usually in the context of the TRIPS agreement and of the World Trade Organization, we're usually talking about tech transfer. I think it's Article 34, but don't nail me down. And so far we haven't even been able in all those years that I've worked in that area to define what tech transfer actually means. There's a bulk of diplomats in Geneva discussing it without ever that I think will be as clarity what tech transfer means. But here you don't have a tech transfer problem. You don't have the usual situation that has been many times accused, that people say, oh, you know what, the patents hamper access at the reasonable price tag. That's not the case here. There aren't even any patents. That's, for me, the ultimate sign of marginalization. If you're not even being considered to be patented, that's how much you are out of the global system. So that's not a tech transfer problem, because, as I tried to say in the beginning, the patent system is geographically limited. All of these countries could, in theory, just take the intellectual property that is patented in the US and produce it themselves there. But that's not going to happen because they don't know they don't have the infrastructure, no, blah, blah. So I think here there needs to be more thinking about how to bring in developing countries into the system. That's really important from a public health perspective, from a corporate social responsibility perspective. It's also important because this is also a market. I mean, this is business we're talking about too. This is like consumers. This is a consumer opportunity. This is like business opportunity. On the other hand side, I fully understand the patent people, and I know why they have been seriously reluctant of touching this. I have worked with many patent offices in developing countries trying to help them figure out how to manage with patents. And I have seen situations where the patent applications, they were used because the table was wobbly to avoid that the table moves. Or in another country, they put the patent application in boxes in the cellar for 5 years because they really had no idea what to do with this. They had nobody who could examine the patents. They had nobody who could read this. So they got the applications, they put it in the cellar, and the community said, we have a patent backlog, I'm so sorry. I get it, you know, I totally get it, that if you're a reasonable patent attorney in a big corporation, you do not want to put up with this, basically. You know, I mean, patent system is a highly sophisticated system of capitalism. It requires functioning legal systems. You're disclosing to the world your idea. You're not keeping it secret. And if someone else is going to use it, you need to be able to take recourse to the courts. And you need to be able to rely on the legal system to get your right. Otherwise, you have just told the world what you did, and that was it, you know. And there goes your trade secret and your business. And if a country can't guarantee that to you, why would you disclose it? That's kind of like useless. It's property rights over intangibles, over stuff you can't touch. It's property rights over stuff which is written on paper. And if these property rights have no meaning, it's essentially a piece of paper, not more. So it's a it's a tricky situation, because do you seriously want to motivate companies to cheerfully say, why don't you patent more in developing countries, knowing what they're going to get themselves into? Or you're going to make a push through the World Trade Organization, through the US trade representatives, what have you, and say, guys, what you do is just so wrong, and I'm going to put you on a blacklist because you're not TRIPS compliant and you don't get your patent situation in order, and it's just wrong. I would be reluctant to take sides here. I can just tell you, I have seen it. I've seen it on the ground. I thought it was hilariously funny. But I didn't see, I think blaming anyone in this mess is the wrong way. Probably we need more development aid, more development assistance. We need political will to get this drama in order somehow. It's not going to be a quick fix. You don't create patent attorneys overnight. You don't create judges who know what they're doing overnight. You need patent examiners. You need people who understand the technology. That's not something you can just force people to have, no matter how many free trade agreements you conclude with them. But the reality is that, and that's not a good reality. So there's maybe, I thought half an hour is so long, I need to speak slowly, and now I realize I only have 5 minutes left, completely get the time wrong. Okay, so let me come to what I think was another shocker for me. So the Framework Convention on Tobacco Control is kind of like the game changer in this industry. I had my junior take a look another time at the treaty. The word patent is not mentioned in the treaty. Wow, guys, what happened there? Total blind spot. Total blind spot. I mean, I want to check if the Convention on climate change also has forgotten to talk about patents. How could that happen? These guys who said, and I was an intern at the time when that happened to WHO, and I was in these rooms next to the swimming pool where they were sitting discussing this convention. And now with hindsight, I thought, Jesus Christ, these guys must have made up a static picture where they thought like, well, it's all going to stay like that. There will not really be anything around intellectual property. It's never going to happen. They're going to sell their cigarettes so everybody knows they're dangerous, and that's it. And bang, and then you see the growth rates, and you see the patent volume that's been generated, and we have no governance structured from a public health perspective on that. Complete blind spot. I don't know. Maybe it's good the WHO didn't touch patents, I don't know. I mean, there are obviously other conventions, treaties, arrangements that govern intellectual property, but specifically the Tobacco Convention doesn't think about it. They haven't said it's good, it's bad. They haven't said anything around how to govern patents or how to manage patents in the public interest or what should happen with this patent. None, it's just not thought of. This has happened several times. The Austrian technology strategy also never mentioned patents until we changed it. And these things just happen as accident because I think because people haven't realized it about the power that IP has, and they still keep thinking it's a nerdy thing for a bunch of tech weirdos, which it is, but it's more than that. Yeah, so I think since there are a lot of people from business here, I would hope that we could start thinking as a first step about IP strategy. If you don't have a strategy, you don't have choices, and you're not able to change it. Not good. And this should not be a legal strategy, it needs to be a business strategy. We need you to think about it, not your lawyers. I know how your lawyers are thinking. That's great, that's a whole universe of logic which is fascinating in and by itself, but we need to think, how can we manage the intellectual property which offers a puzzle in the solution towards fighting a major pandemic, God willing, in a way that we are sure it's going to break that equation. If BAT and Philip Morris are just at each other's throats for patent infringement, that's not really where I see the future in that question. I see the future where industry sits together and thinks as a team or as a group about how they can manage their IP under a public health paradigm, how they can manage their IP to assure access of this technology in developing countries, and where they're starting to think, how can we proactively assure we are aiming at realizing these goals that we are having to fully innovate and revolutionize this sector. And I think this is really the first step. And for this to happen, we need to think, what's the patent paradigm? What's the innovation paradigm? What's your corporate social responsible business strategy? How does the patent situation look like with respect to our international development goals? Nobody has thought about it. How are we going to manage the patent profit motive? We probably need some more data, and we need more information on the value of the public health value of the intellectual property. We need corporate social responsibility profiles around patents. But I think above all, that follows second. Above all, we need will and motivation to do something about it, and we need to overcome lack of awareness, and we need you non-patent people to realize this is something which concerns you and not just your legal team, because your legal team is here to serve to fulfill your goals and not the other way around. So I really hope that with this very short intro to the world of intellectual property, it has created some appetite and interest to start thinking about IP in a more strategic way, and that these strategic goals are related to public health goals. The FCT has forgotten about it. Sometimes this happens, even if the biggest thinkers in the world come together. But an industry-driven self-initiative, I think, could be a starting point to think about it as a way of bridging gaps and of making sure technology becomes available to those who need it.